Good morning. I would like to thank the organization for holding this Congress, which brings us together around an important issue, such as the transfer of the farm. Spanish law has a particular rules on transfer holding farm. These rules specifically serve the purpose of ensuring the entity of the farm itself along with its conservation. But unfortunately, this legislation is weakly enforced and protected in such areas. Spanish agricultural legislation is enormously dispersed and fragmented. This, in part, is due to the particularities of the structure of the Spanish state, where 17 landers, or autonomous communities, each have their own strength and power in agricultural matters, generating different legislation and different economic regimes. This, therefore, reduces the efficiency of the Spanish agrarian sector, and the tax is further complicated by a highly decentralized territorial organization. As a result, a future reform should consider a strengthening of law and improved bureaucratic procedures. In this sense, particularly crucial at time of transmission for the future of agricultural enterprise. Spanish law contains rules on the transfer of agricultural holding, in particular, granting tax benefits to facilitate the transfer. There are also 6 specific rules: inter vivos transmission and mortis causa transmission. There are rules to facilitate the access to the holding farm for the women and for the young farmer. And we can see too, tax incentives are also provided for the transfer of small farms to larger ones in order to increase competitiveness. Since the insufficient size of many farms is one of the problems which affect future viability, Spanish legislation provides measures to stimulate the land market and allow easier access to ownership and leasing. Through its regulation on terms and extensions, along with reduction of the minimum duration of leases, it allows a substantial increase in the supply of land to be leased, as well as generated a more agile and open market. With regards to access to property, it can be said that high land prices make it difficult for farmers to acquire ownership on land when they want to embark on farming activity or indeed expand the area of land under cultivation. This rise in land prices threatens us with the possibility of fixed population in rural environment. It also brings the possibility of increasing the number of agricultural access as the trend toward grazing leases areas disadvantage landowners. In order of these problems, some authors have proposed leasing with an option to buy, as we have in the urban environment. However, the limited success we have in relation to housing may indicate a similar lack of usefulness in the rural environment. So, from various perspectives and in various ways, Spanish law offers options when faced with a decisive moment for the evolution of agricultural activity, such as the moment of the transfer of the farm. Now, we will see other specific measures that are provided in order of these subjects. On one side, the law on rural leases provide for a preferential right of acquisition in the case of trust. I mean, the landowner and transferor must notify the tenant in a reliable manner of his intention to sell and must indicate the essential element of the contract. In this way, the tenant may exercise his right and be granting preference in opting to acquire the property. The tenant shall have a term of 70 days as from the date of receipt of the notification to exercise his right and must notify the transferor thereof in an irrefutable manner. The disadvantage is that, or it does option, is that this right implies an advantage for the tenant, but it's a limitation for the owner, or a hindrance for the property that assumes new restrictions and new conditions. This would have the effect of discouraging landlords from renting. In any case, in order for the law to be an effective instrument, it must provide sufficient security to both tenant and landowner and be equally attractive for both. On the other hand, taking into account that the aging population of farm owners is one of the main brakes on the modernization of agriculture, many strategies are in place to facilitate access of young people to the ownership of the farm. There are measures to promote the installation of young people in the tasks of direction and management on farm, especially in the case of priority farms. These measures provide for tax reliefs on personal income tax, as well as a specific more advantageous treatment in other subsidies, aid, and tax benefits. In this sense, the communication from the European Parliament Commission to the Council, the European Economic and Social Committee, and the Regional Committee in the document The Future of Food Agriculture propose that member states adopt appropriate incentives to facilitate the exit of the older generation and increase the mobility of rural property. In addition, there is an increased need to support action that stimulate the transfer of knowledge between generations and facilitate succession. In the area of protect the women in rural areas, Spanish law has a specific regulation also. Likewise, Spanish law contains specific rules to encourage the incorporation of women into the agricultural sector. Law 35/2011 takes into account the fact that the presence of men in the rural world is in the majority. And to modify this inertia, it adopts a series of incentives to favor the incorporation of women into the ownership of farms. The law explains that within the scope of family farm in the rural environment, many women share agricultural tasks with men, taking on a large part of them and contributing both access and work. However, in the majority of cases, only the man appears as the owner of the farm. In Spain, more than 70% of owners of farm are men. In Spain, there are obviously no legal limitation for women in terms of access to agricultural property, nor in any other type of property. But stereotypes are still in place in the rural environment. Women's work continues to be understood more as a family allowance to supplement the main income rather than an actual economic contribution. Although there have long been sufficient corporate measures in the civil or in the private and commercial legal system for women to have the same rights as men, the social reality shows that women working on farms have not made use of such corporate measure. That is why the state tried to adapt the legal framework to the social reality. The Act seeks to achieve this objective through the legal measure of shared ownership. As is well known, an inveterate demand in the agricultural environment has been to achieve a legal statute for the collaborator of the farm or partner of the farm, which in many cases is a wife. In France, for example, attempts had been made to resolve this issue through the measure of chalet différé, and in Spain, through the measure whose name is shared ownership. This is not a big legal innovation, but sample a way of making women's work on the farm more viable or visible by encouraging them to be the owner of the farm alongside their husband. A shared ownership agricultural holding is defined as economic unit without legal personality and liable to taxation, which is set up by married couple or unmarried partner for the joint management of the agricultural holding. On the other hand, on the subject of the transfer for agricultural holding, there is a basic law 19/1995 of the modernization of agricultural holding, which lay down particular rules in the various cases of transfer of agricultural holding. In any case, first of all, it's necessary to say that it should be noted that this law is outdated and has already been superseded by many community regulations, but is still in force. It's based on an agricultural model that is essentially family-based and was designed to meet the difficulty or the difficult challenge on Spain's integration into the European Union and to adapt farm to a more complex and demanding agricultural policy by tackling a series of agricultural adjustments. In this law, the principal concept is the priority agricultural holding. This priority mode of enterprise is defined by subjective criteria linked to the owner as well as other objective criteria. This law basically contains tax benefits to encourage the transfer of agricultural holding. There is tax benefits in the inter-vivos transmission or inter-mortis transmission in different sense and in different situations. For example, you can read this specific tax benefits in the moment of the transfer holding farm. And we have other regulation about transfer of the holding farm in our specific civil code. In the area of transmission mortis causa, the Spanish civil code contains some rules to maintain the company as a unit at the time of hereditary succession. There are several articles important in this sense, but the idea is that the testator, who in order to maintain the company of whatever kind wants to keep it undivided, may do so provided that the legitimate son is paid in cash to the other co-heirs in order that one will receive the company as a whole and the other co-owners will receive their share of the inheritance in money. Likewise, the unity of certain types of property is reinforced by establishing that when an item is divisible or is very unworthy of division, it may be awarded to a co-occurrence, paying the others the excess in money. The problem is, however, it will be enough for one of the S to ask for its sale in public auction and with the admission of foreign bidders for this to be done. All of this is not enough to promote the transfer of the far in good condition, because the civil code contains a very generic and very weak provision on the undivided maintenance of an economic exploitation, such as a farm. The transfer of the company as a unit is a problem in Spain, because to maintain in this moment the enterprise like a unit only depends on the voluntary of the will of the testator, but it's not compulsory for him. And on the other hand, if the single S must pay to the other co-owners their part with hereditary or extra heritable money, the reality shows that sometimes this repayment cannot be done. All of this may discourage the possibility of acceptance of the succession to the farm. I mean it's necessary to reform all this part to guarantee the transfer of the farm as a unit in the moment of the mortis causa transmission. And on the other hand, when dealing with the issue of the transfer of the agricultural enterprise mortis causa, another problem is to consider the capacity of the successor to ensure the best viability of the farm. On the other hand, it should also be pointed out that in those Spanish territories that have a particular regulation in the field of inheritance law, the system of inherited pact is considered as another means to guarantee the unitary transfer of the agricultural holding for the moment of the death of the owner of this holding. I mean, we have in Spain 70 different regulations for the inheritance of the transfer a company in the moment of the mortis causa transmission. In different territories in Spain, it's possible to maintain the holding farm in the transfer mortis causa with another type or instrument, legal instrument. There is a particular instrument for this objective through the pact succession. This agreement on succession had been defined as the mechanism of cohesion of the family farm. The pact of succession is a contract by which a person undertakes with others before his or her death to hand over to them some property or rights when his or her death occurs. In this way, the manor and the successor to take over the agricultural exploitation or holding in the event of the holder's death could also be determined. For example, this agreement on succession only is possible to use in the Basque Country, in Navarra, in Galicia, in Aragon, in Catalonia, or in the Balearian Island. But it's not possible, for example, in the territories that their legislation is only the civil code. Then we have different instruments to guarantee the transfer of the holding in the moment of the mortis causa transmission. There are different instruments, but everyone is not so sufficient to guarantee the holding as a unit. Finally, as regards the inter-vivos transfer of the agricultural holding, it's necessary to say that is another problem in our legislation, because it's not possible to transfer the company as a unit or in the same moment, because its transmission or its any part of the company is necessary or is depend of his singular rules. All of this is very inefficient economically. It can be concluded from all the aforementioned that while from the point of view of tax law with tax benefits, the transfer of the farm can be encouraged and made more dynamic in order to ensure the continuation of the farm, from the point of view of private law, other types of rules should be adopted to improve the condition of transfer. This is true especially in this time of crisis, where the profitability of the sector must be better promoted with legal rules rather than with an state economic budget. Thank you very much.
Professor Muniz, thank you so much for your presentation. And I would like to ask others, do you have any question or not, or remarks?
I would like apologize because my English is not so good. I don't know if you can understand the presentation or there will be any problem. Or...
I have a question. Can I ask? Because if I understand good your presentation, the subject of agricultural legal relations is there is no possibility to be a woman or only man? I don't mean Spanish.
No, the problem is, for example,
discrimination of right of women to agricultural properties. I don't understand this.
Yeah, no, the idea is, for example, in Spain, the majority of the ownership of the holding enterprise is the men. There are few women as owner of the holding company.
No, I understand that, but it is a restriction for women to be holders. What? No. Okay.
No. The problem is that there are the same instruments for the men and for the women to arrive to owner the enterprise, obviously. But the problem is very traditional that the wife or the women in the enterprise only apport only the help. It's not a participation with a contribution or retribution. Do you understand me? Yes, and the idea, the state wants that the owner of the holding farm enterprise appear the women as a ownership. Do you understand?
Mm-hmm. I understand. So it is more historical, this situation, yes. More like legal. Okay.
And in this moment, the idea is how to promote that the women appear as the owner of the enterprise, not only his husband.
To make education from childhood in equality, yes. Women and men. Yes. Okay. Thank you very much.
Thank you very much. Thank you.